Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about the Bangladeshi building collapse. Cases that should have gone to the Supreme Court of Canada, but didn't. If you may recall, several years ago, a building in Bangladesh where Loblaws or Superstore was having their Joe Fresh garments manufactured collapsed, killing many people. An action was commenced in Ontario on behalf of the families of the survivors as well as the families of the deceased for recovery of damages as a result of the building collapse. The claim was based in negligence, that Loblaws, which is based in Ontario, had been negligent in their international operations and in using that building, which was structurally unsound, for the purpose of its garment manufacturing. The case was unfortunately dismissed on the basis of the fact that the law of Bangladesh applied to the claim, and although the claim could be brought in Canada, because Bangladeshi law had already passed its limitation period, the claim was no longer viable. The families continued their claim all the way to the Court of Appeal and ultimately sought leave to the Supreme Court of Canada, which was dismissed. And this case raises a really important issue. If another country has a limitation period that is so short that it implicitly prevents people from bringing these actions against multinational corporations headquartered in other countries that are much more difficult to access, should the law of that other country really fairly apply? And doesn't that allow multinational corporations like Loblaws to put their operations somewhere that would disadvantage people if they are involved in situations like this and prevent them from being sued? I mean, they're the ones with the power in these types of circumstances, and they can use different laws of different countries and set up their operations where they see fit in order to avoid legal consequences. Isn't it more fair that companies not be permitted to do that because they have so much power and so many resources, and because the people that are ultimately affected by those decisions, ultimately harmed by those decisions, are usually people who are living in poverty or who have difficulty accessing these resources? I think the Supreme Court of Canada missed the significant role that the power imbalance between the Bangladeshi families and the Loblaws Corporation played in which area of law should apply. And conflicts of law regulations are far too cold, and the Supreme Court of Canada had the opportunity to make them a little bit more feeling, to make the justice system for those people a little bit more fair, and to allow individuals the ability to reasonably bring claims in a forum that is convenient to the corporation, accessible to them, and reasonable for everybody. That's not what happened here, and the Supreme Court of Canada missed an opportunity to give justice to people who have lost a lot as a result of the alleged negligence of Loblaws in setting up their operations where they did. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative has been instrumental in putting these videos together. Please like, subscribe, share with your friends, and tune in next week.